of the things that I promised when the Renters' Rights Bill was first talked about was that I would ask all of the fabulous agents in the group to ask landlords any questions around the Renters' Rights Bill that hasn't been answered or they can't find the information for. So today I've got a list of questions from landlords and I'm going to be answering those for you, the weird and the wonderful and whatever they may be. Yes, you will. You'll be using a new Section 8 ground and you will need to give 4 months notice to do this. But you can only give that notice after the tenant's been in for at least 8 months. So it's going to be a 12-month period from when they first move in. But yes, 4 months notice after that point is what you'll need to serve to be able to sell your property or move you or a family member back in. So really this is sort of a wider question of if there is a breach within a term of the tenancy that's persistently being breached, what can you do? Now, you would have no option but to use the Section 8 grounds around breaches of the tenancy term, but you'll need to be guided quite carefully on this because obviously they are discretionary grounds and going to court is quite a thing, and there is a risk if you do that the tenants may then stop paying rent, that kind of thing. So an agent will proactively work with you very hard to make sure those breaches aren't happening. But if you come to the position that it's not going to change and as you say they are taking down smoke alarms, one thought there is to go to the council yourself because the council will then at least you'll have the evidence that they were taking the smoke alarms down to protect you. But yes, you would proceed to court on that ground with a really good evidence file with the aim to get that evicted. So anyone can issue a Section 8 notice. The problem is how easy it is to get them wrong, especially in this new world. So I would always say, ask your agent to get a solicitor to draft the notice for you, and there'll be a small fee for that. But the nice thing around using an agent is that they will have the right people at a reasonable fee. So I would always suggest that, especially as there could be a delay getting there and you don't want it to be thrown out, you get those, spend a few pounds to make sure that you get those served correctly. So it's that 12 months period, yes. So you can serve your notice 4 months after 8 months. You don't have to wait till 12 months to serve the 4 months. So the tenants have the enjoyment for a 12-month period of living in that property undisturbed. Unlikely to at this point. I mean, the bill's not quite through its final hurdle yet, so you never know, but I'm not expecting those notice periods to change from currently billed. And there are various different periods under the different notices in the Section 8. So obviously there's less for antisocial behaviour than the 4 months. There's less for serious rent arrears, that's your 28 days. But yes, I am not expecting those to change. Good question. There are a number of elements that a lot of us in the industry have lobbied with the government to consider, mostly because they will adversely affect tenants. And we would all like parents who move to a certain area for school and want to have a fixed amount of time, because if they can't have a longer fixed tenancy, you can sell or move back in after they've had that 12-month period. So it doesn't give them the protection that they're ideally looking for. But the answer, I presume, from the government point of view is no, you can't mutually agree it, because they're concerned that there will be push or pressure, especially if it's a competitive market for tenants. So it's challenging for them to find a property. So they're just saying cleanly at this point, no, you can't negotiate it. So I will say my bet is on October at this point, but these things do change and we are at the whim of government timetables. But at this point, I would say it's likely to be October. So unfortunately, again, another one that we are worried about tenants. And I think the next question on your list, which I'll cover in this one, is really the same around overseas students or people that have adverse credit and can't necessarily pass referencing. Lots of us want to give those people the opportunity and to move into the house, but by not taking rent up front, which we will not be able to do, we can't kind of give ourselves that extra kind of security blanket to make up for those issues. And there is also the concern that now tenancies are essentially indefinite in terms of their periodic nature. That guarantors, whilst really useful, can't necessarily be held forever. and there are court cases that show it being reasonable to do that. So, I think it's a real concern for tenants who don't fit that mainstream criteria, and our job, of course, is to protect our landlords, and that's what we'll prioritise. A challenge, I think, and one that was raised in the Lords, so you never know, something could come out of that. So the Deposit for Life scheme was something that was talked about in the earlier iterations of the Renters' Rights Bill, the Renters' Reform Bill, but I think I'm right in saying that it's not part of it at the moment. So the Deposit for Life scheme was meant to be making it easier for tenants to move from property to property, but I don't believe there's any focus being put on that at the moment, so watch this space for that one. Not that we know of for now, so again, something to watch out for, but not that we can see at the moment. They will be, absolutely, because they're not within the Housing Act, so company lets will be outside of this legislation. So it's an interesting one, this one, because in Wales, when they changed to their occupation contracts, this was actually a huge piece of work. We don't yet know what requirements will be in terms of written paperwork. We do know that the legislation is meant to come in one go. So if it comes in on the 1st of October, and they have an ongoing tenancy agreement that isn't a short hold tenancy agreement, as it's likely to be. Once that bill comes in, the fixed term that they are in won't mean anything, because the statute will say that they now have a periodic tenancy, and those Renters' Rights Bill rights are in place. So whether we have a time frame after that to issue some paperwork, or whether how long that will be and what that paperwork will look like, or whether they will just allow the tenancy to be read as if it's in line with for a period, we've yet to find out. So definitely on one of my homework lists to prepare whatever's needed for all the agents to issue that in a timely way when it comes. So you should there are still obviously rules around overcrowding. So the children element, that's how you would deal with that, in terms of you can go to the council if there is an issue with overcrowding in a property where it's not safe and it's not safe for that level of habitation. With pets, you will be able to refuse consent on reasonable grounds. So it should be reasonable not to put 6 huge dogs in a one-bed flat with no garden with a balcony. I'm sure that's going to cause issues, not just within the property but with neighbours. So you'd have to take on a case-by-case basis, and I'm sure my phone will be ringing with lots of questions from agents trying to say, is this reasonable or not reasonable? And we will all be working it out together. So the important thing is, protect yourself as a landlord, as an agent, to make sure that you're not discriminating on that ground, and make sure that you have good documented evidence as to why any decisions have been made. That's key.